The Supreme Court has just issued a significant order regarding the critical Second Amendment Preservation Act challenge that has been making its way through the federal court system. While the decision may initially appear to be a setback for Second Amendment advocates, there are actually several positive developments emerging from this latest ruling that deserve careful examination. The court has denied emergency review for the second time in this case, which involves Missouri's Second Amendment Preservation Act, commonly referred to as a SOPA law. This denial comes after months of legal maneuvering and represents another chapter in an ongoing battle between state sovereignty and federal authority over gun regulations. However, the story doesn't end with this denial, and the case is far from over. To understand the current situation, we need to revisit what happened previously. The Supreme Court had already denied a stay request in this case once before, with only Justice Thomas voting in favor of protecting Missouri's SOPA law. That earlier decision sent the case back to the Eighth Circuit Court of Appeals, where the lower court's ruling against Missouri was ultimately upheld. The Eighth Circuit sided with what was then the Biden administration, striking down the SOPA law in its entirety. The law itself, which passed in Missouri in 2021, represents an interesting exercise in state authority and constitutional interpretation. The Second Amendment Preservation Act established Missouri's own interpretation of the Second Amendment and created specific restrictions on how the state would cooperate with federal agencies attempting to enforce gun laws that Missouri believes violate constitutional rights. Under this law, Missouri officers, agents, and government officials were prohibited from assisting federal agents in enforcing what the state considers unconstitutional federal firearms regulations. What made this law particularly unique was its enforcement mechanism. Rather than relying solely on state officials to uphold the law, it created a civil remedy allowing any Missouri resident to sue a state official who helped enforce federal gun laws that the state deemed unconstitutional. This approach effectively transferred enforcement power from the government to the citizens themselves, creating a grassroots accountability system. When the Biden administration challenged this law in federal court, the district court ruled decisively against Missouri, issuing what amounted to a universal preliminary injunction that struck down the entire SOPA law. Missouri appealed this decision to the Eighth Circuit and simultaneously sought emergency relief from the Supreme Court, but that initial emergency request was denied. The case then proceeded through the Eighth Circuit, which heard expedited arguments before ultimately ruling once again in favor of the federal government. Missouri's response was to file another petition with the Supreme Court, though it remained an emergency request dealing with what lawyers call an interlocutory issue, meaning there was still no final judgment in the case. The state made compelling arguments about how the Eighth Circuit had reasoned its way to the decision. According to Missouri, the appeals court acknowledged that the structure and potential operation of the SOPA law could be valid, but struck it down anyway because of its underlying Second Amendment purpose. Missouri argued this reasoning contradicted established precedent. One of the most troubling aspects of the Eighth Circuit's decision, from Missouri's perspective, was the court's finding that state officials could be sued simply for complying with state law. The appeals court essentially determined that compliance with the SOPA law, even if it involved no active enforcement actions, constituted a form of enforcement itself. In other words, simply following state law and not assisting federal agents was treated as an affirmative act of obstruction. The political landscape shifted dramatically while this case was pending before the Supreme Court. The Biden administration, which had aggressively opposed the SOPA law, gave way to the Trump administration. Initially, the new administration delayed its response for several months, causing uncertainty about how the case would proceed. When the Trump Department of Justice finally filed its response, it came after the case was apparently taken over by a Second Amendment task force within the department. The Trump administration's position proved to be more nuanced than many had hoped. While they continued to argue that the SOPA law was invalid and that the lower courts had reached the correct decision, they also made an important concession. The Trump DOJ acknowledged that the judgment obtained by the Biden administration was overly broad and too comprehensive in what it granted to the federal government. They promised that if the Supreme Court denied review and sent the case back to the district court, they would voluntarily release portions of that judgment. Missouri seized on this concession in its response to the Supreme Court, pointing out that the Trump DOJ's willingness to narrow the scope of the injunction was actually evidence supporting why the court should grant review. However, the Supreme Court was apparently not persuaded by this argument. After considering the case at conference on September 29th, the court issued its order list the following Monday, denying emergency review once again. Despite this denial, there are genuine reasons for cautious optimism about how this case will proceed. The Trump administration has committed to following through on its promise to release some of the judgment once the case returns to the district court level. This means that instead of facing a complete and total injunction against the entire SOPA law, Missouri may have the opportunity to implement at least portions of it. The nature of this case as a pre-enforcement challenge adds another layer of complexity and opportunity. Because the law hasn't been fully implemented, and there's uncertainty about exactly how it would operate in practice, there may be room for the law to be put into effect in some form. This would allow both the state and the federal government, as well as the courts, to observe how the SOPA law actually functions in real-world situations rather than dealing only with theoretical concerns. As the case moves back to the district court level, several critical questions will need to be answered. First and foremost, will the Trump administration keep its promise to narrow the scope of the injunction? The government's credibility and commitment to its stated position will be tested as soon as the case returns to the lower court's jurisdiction. Second, what portions of the SOPA law might be allowed to take effect, and how will Missouri implement them? Third, how will the federal government respond to whatever limited implementation occurs? The district court will need to carefully consider how the SOPA law operates once it's actually enforced, at least in part. This practical experience may provide valuable insights that were missing from the earlier theoretical analysis. If the case is appealed again to the Eighth Circuit after this next phase, that court will have the benefit of seeing real-world evidence of the law's effects rather than relying solely on predictions about what might happen. The possibility exists that once the law is partially implemented, the courts may determine that a total injunction isn't necessary. Perhaps certain applications of the SOPA law are problematic while others are perfectly legitimate. This more nuanced approach could allow Missouri to maintain some protections for Second Amendment rights while addressing any legitimate federal concerns about obstruction of law enforcement. Looking forward, this case will continue to develop as it works its way through the lower courts once again. The Supreme Court's decision not to intervene at this emergency stage doesn't necessarily mean the court will never hear the case. If Missouri can demonstrate that partial implementation of the SOPA law works effectively without causing the problems the federal government predicted, that could strengthen the state's position for future appeals. Conversely, if implementation reveals genuine conflicts with federal authority, that information will also inform future legal proceedings. The outcome of this case has implications far beyond Missouri's borders. Other states have enacted or are considering their own Second Amendment preservation acts, and the legal principles established in Missouri's case will likely influence how those laws are treated by federal courts. The balance between state sovereignty and federal supremacy in the context of constitutional rights remains an evolving area of law, and this case sits at the intersection of multiple important constitutional questions. As developments unfold in the district court and the Trump administration's promised concessions are either implemented or abandoned, the full picture of where this case is headed will become clearer. For now, while the Supreme Court's denial of emergency review is disappointing to SOPA supporters, the case remains very much alive with potential pathways toward at least partial vindication of Missouri's efforts to protect Second Amendment rights within its borders.